So the starting point really of the talk is what Labour said that they were going to do through their manifesto. Change not just in employment law, but across the board, was a term that was used as the heading of the manifesto, as the aim, and the intention being that there would be substantial change to workers' rights and more generally to the world of employment. And the promise that was made was that an employment rights bill would be handed down within the first 100 days of Labour being in office. Now, because that would have been on a Saturday, those in the know, which became me when I realised the date of this talk, realised that that would be Thursday, yesterday. Now, what's happened, therefore, is that the bill was published yesterday. It was subject to its first reading yesterday in Parliament. It's 158 pages long, I can tell you that for sure. And the intention of this talk is that I've read it so that you don't have to. One of the things that I can also tell you about the bill is that there is in fact some more information about the intentions through the bill in some of the press releases that have been provided in it than you'll actually find in the bill itself. The purpose of the bill has been set out through a number of press releases. The purpose through the joint press release from the Department of Business and Trade, Jonathan Reynolds, the Business Secretary, and Angela Rayner, the Deputy Prime Minister, is to upgrade workers' rights across the UK to tackle poor working conditions and benefit businesses and workers alike, to boost pay and productivity, showing the benefits of a pro-business, pro-worker approach. The clear intention of the Labour government is based in the philosophy that increased job security and flexibility leads to a more productive workforce. You'll all be aware that the productivity stats for the UK are not good. And so Labour are clearly hoping that they will generate a more productive workforce, leading to a stronger economy, and ultimately, in due course, more tax available to them to pay for some of the reforms and some of the pay rises that we were all already aware of. Another clear aim that you'll see as we go through the bill is to increase workplace consultation. Not necessarily always with trade unions, but where possible, through an increased involvement of trade unions. So, having committed to producing a bill in 100 days, that has taken place. But in order to provide that bill in 100 days, it's quite clear when you go through it that there are a number of points that have not yet been determined. But more than that, there are a substantial number of defined terms in the bill. Some of those are defined, some of them are in capitals, but there is simply no definition of what it means in the bill at all, presumably partly because of the rush to get the bill published. Some of them say that they will be defined through statutory instrument. And so what that's allowed the government to do is produce a bill within the time period required, but for a substantial number of important parts of it, they will be subject of consultation, and in due course that clarity will be provided through statutory instrument. The press releases make it clear that the intention is that this is the start of a consultation period. Now, that's not just from what I can tell through Parliament, but more generally with trade, with industry, and with trade unions and employee representative bodies. In the main, the reforms are not intended before a period of 2 years' time. So a substantial amount of what we're looking at is not actually intended to be in place before autumn of 2026, give or take. And what I want to do is try and look at some of the headline topics. We'll look at whether what had been said earlier has come to fruition. So starting off, day one rights. This was one of the big headlines through the manifesto. In the plan to make work pay, and in a number of other press releases, it was indicated that day one rights for all workers would come in. Specific leave for sick pay, holiday pay, parental leave, and unfair dismissal, of course, has been the most talked about one of those day one rights. What's readily apparent, though, is there was some pushback against that. And of course, it's much easier to say day one right to unfair dismissal in a manifesto, slightly more tricky when you then need to get that into a bill that's going to work its way through Parliament. And so more recently, Jonathan Reynolds, the business secretary, said, "I wouldn't like people to think the employment law framework will change overnight when we present that bill," no doubt responding to substantial concerns of employers. And some of you may have seen in the press the concern about the idea that unfair dismissal rights from day one will cause serious problems and might actually cause people to be reluctant to hire. And so what's become the discussion more recently is what kind of pressure valve there can be in relation to that idea of having day one rights for every employee. So the question is whether for probationary periods, which you will have seen become the important question, whether Labour have stuck with what was in place beforehand, with an employer having the right to determine a probationary period, or whether they've twisted and put in the bill some kind of probationary period. What's come in is we've got unfair dismissal rights from day one. That appears to equate to about a third of the workforce. A third of the workforce have been employed for between a day and up to 2 years. In order to give some reassurance to the world of employers, it's been said in the press releases this is one that is definitely not for implementation before autumn of 2026. You might think that that could lead to a surge of dismissals as we get towards that period. And importantly, this is not actually, the way it's drafted, it's not a day one right. The way that the bill deals with it is just deletion of section 108, deletion of the qualifying period. And so in theory, what that would mean is once someone has an employment contract signed off, they have a right to unfair dismissal, even prior to the time that they've actually started work, a minus whatever period right. Because of that, Section 108A will be introduced to the Employment Rights Act, which will say the right doesn't actually exist until you have started work. An important consequence, though, of the deletion of Section 108, assuming that the bill becomes law, is that there no longer will be any provision about the qualifying period in the Act. And what that means is that if a subsequent government wants to introduce the concept of a qualifying period again, they'll need to do it through primary legislation, much more difficult than changing the period through a statutory instrument. In terms of the probationary period, the stated intention is that there should be a period to allow a proper assessment of an employee's suitability for a role, as well as reassuring employees that they have rights from day one. And so the question for the government has been, how do they balance those rights? The intention of having a probationary period is that businesses are enabled to take chances on hires while giving more people confidence to re-enter the job market or change careers. And of course, because there is currently a deficit of workers, part of the aim here is to get people who have chosen to be out of work back into work. So at the moment, that period is not set out in the bill at all. It had appeared that the period would be 6 months until very recently, from what was in the press. The press releases yesterday indicated that the government's preference at the moment is a 9-month period. But that's going to be subject of consultation. Equally, during that period, and one might think that that effectively introduces a qualifying period of 9 months, But during that period, the stated intention is that fair dismissal isn't prevented, and there will be a lighter touch process to be followed to dismiss, again, to be subject of consultation. Your guess is as good as my guess as to what a lighter touch process to dismiss in those 9 months will be. Also out for consultation is what the compensatory regime would be if dismissed in those 9 months. The intention being, it would appear, or at least an acknowledgement, that that possibly should be less than the compensatory regime that's available at the moment for an unfair dismissal. And so it appears that there will be a 9-month period, or a different period subject to consultation, during which time people can be dismissed with a lighter touch process, and during which time the compensation is likely to be an amount lower than you would get from basic award and compensatory award in your normal unfair dismissal. All of that subject to consultation, unlikely that any of that's going to be clear anytime soon, but nevertheless in the bill with 100 days. And also in the bill, the day one rights that are included and that we'll come on to in a bit more detail in due course, do include sick pay from day one, a right to parental leave from day one, a right to paternity leave from day one, and a right to bereavement leave from day one. So the next high-profile subject that was covered is zero-hour contracts. The initial terminology, and I suppose the manifesto terminology, was that there would be a ban on zero-hour contracts. Of course, that doesn't work so well if some people like them. If the employee wants to be employed under a zero-hour contract and finds that flexibility useful to them, then that wouldn't promote the kind of flexibility in the workplace that the government say that they want to support. And so what happened more recently, and at the Labour Party conference, the terminology used by Angela Rayner was the desire to get rid of exploitative zero-hour contracts. There is a ban, but it's not a blanket one. Despite that, the press release still says that this is ending exploitative zero-hour contracts. And so the concept, therefore, it would appear, is those contracts that are covered by the ban are exploitative. Those that are not exploitative. The changes are intended to be through amendment to the Employment Rights Act. You might think that they might have thought of a different term than the Employment Rights Bill, when a lot of what they propose to amend is the Employment Rights Act. Having two Employment Rights Act, one of which amends another Employment Rights Act, might prove to be confusing in due course. The intention is that these protections will cover not just zero-hour contracts, but also what's termed at the moment in the bill as low-hour contracts. And from the press release, that appears to be a specific anti-avoidance provision. It's so that an employer can't get round a ban by having contracts that are 1 or more hour contracts. But the way that it works is that an employee will have a right to a guaranteed hours contract if they work regular hours over a particular reference period. Now, importantly, the reference period over which the employee is expected to work is not defined. As things stand, the start date is clear on the bill. The start date of the reference period is either the date that the Act comes in, if they're employed at the time of the Act, or alternatively the date that they start to carry out the work that's to be considered. But the end of the reference period is at the specified day, which is a term in capitals without a definition in the bill at all. And so, as I indicated, the press release, in fact, is more helpful to us than what's in the bill. In the press release, it's indicated that the intention is that there's going to be a 12-week reference period. And so I would anticipate that in due course, specified day will be the period ending with 12 weeks after the start of the reference period. In order to get this right to a guaranteed hours contract, the employee must work over a minimum reference period hours number. The minimum number of hours is not defined and is subject to consultation. And so if an employee works on a 0 or low hour contract but doesn't work above the minimum number of hours, they're not caught by the right to a guaranteed hours contract, certainly as the bill is written at the moment. And presumably they therefore are not considered to be someone with an exploitative contract. Equally, the reference period hours that they do work to fall within this right to a guaranteed hours contract must satisfy certain conditions to be set out through regulations as to number, regularity, or otherwise as are specified. Again, something that will become clear, but it's making it quite clear that there are a number of contracts that will sit outside this regime. There will also be a right to review what your guaranteed contract hours are if they change over time. The bill intends to introduce a right to reasonable notice of what shifts you're required to do, or of changes to shifts, or of cancellation to shifts. And there will be regulations to clarify the way in which that's to take place. So where we get to is there will be a ban on some 0 hour and low hour contracts, but that ban will be through the introduction of a right to be given a guaranteed contract after a particular reference period that's as yet unclear. And when you're offered that guaranteed contract, you can turn it down because they want the employee, the worker, to have flexibility. One of the things that's been made clear through the press release but isn't in the bill, certainly isn't clearly in the bill, is where the work is genuinely temporary, there will be no expectation to offer a permanent contract. And this, I think, comes from the hospitality industry raising concerns about seasonal contracts, when someone's employed only for a particular period of time where the demand is high. And so seasonal work appears to be work that is unlikely to be intended to fit within these guaranteed hour contracts. The intention is that there'll be compensation through a just and equitable award up to a permitted maximum number of weeks' pay if someone doesn't get their guaranteed hours contract, but that is to be subject to consultation and a statutory instrument. There's also the addition of a right not to be subjected to any detriment on the grounds of having accepted or rejected an offer of a guaranteed hours contract, or equally having declined to work a shift that someone reasonably believes to be a breach of that new duty. There's also to be the addition of a new automatic unfair dismissal category to cover those who fit within this regime. So if it's due to a requirement leading to an offer of a contract, an acceptance of a contract, or rejection of a contract. So that's 0 hours. Next, worker status, something that's been significant headlines in the press, the intention to try and do away with the complicated tests as between employee and worker and create almost a 2-tier categorization where there are those that are self-employed and those who are employed, encompassing employees and workers. In its manifesto, Labour said it would transition to a simpler 2-part framework for employment status, and that they wanted to differentiate between workers and the genuinely self-employed. Now, the obvious potential problem with that is the mutuality of obligation test. A number of workers do not want to work when an employer tells them to work. They want the choice. And so there is a potential problem of pushing all workers into the test that we know now for employee. And so the question that arises is whether for the moment Labour have stuck with the three-tier test, or whether the bill included provisions to consolidate the worker status into employee. The answer to that is that for now at least, Labour have stuck with the three-tier test. There is no mention at all of any changes to employment or worker status in the bill. There are, however, clear indications through a paper that's been called the Next Steps paper that got published at the same time as the bill, that there will be further consultations, and that those consultations are intended to move towards a single status of workers and to transition towards a simpler two-part framework for employment status. There also is intended to be consultation on the right to someone having a written contract when self-employed. Within the press, there was suggestion that there may be consolidation of time limits to try and create a unitary approach to time limits, and whether Labour would decide to introduce a unification to 6-month period. I think everyone was, because the idea has been that this is to try and give greater rights to workers in general. Realistically, if you're giving greater rights to workers when looking at time limits, you're increasing those time limits. There is no mention at all in the bill of any change to time limits, and it appears that if this was something that was on the drawing board for Labour, for the Department of Business, then it's not something there anymore, because a lot of the time limits included in the bill are 3-month time limits. So we're looking at enforcement of a failure to offer a guaranteed contract. That's a 3-month time limit as things stand in the bill. So it looks like we will continue with differentiation for some particular claims between a 6-month time limit, an equal pay claim, for example, and for other claims, discrimination type claims, a 3-month time limit. The Fair Work Agency. Labour had indicated that they wanted to bring together enforcement so that rather than having a number of different agencies, such as the Gangmaster and Labour Abuse Agency, the agency that deals with policing the national minimum wage, the Employment Agency Standards Inspectorate, that they wanted to bring in a single enforcement body. The terminology that was used in a number of press releases from Angela Rayner was that they wanted the agency to have real teeth. The business representative bodies, including the Federation of Small Business, have spoken about those kinds of uses of terminology. And Craig Beaumont, the head of public affairs, indicated that as well as unions, 1 million small employers deserve to be recognised and heard on these measures when the government consults about all of them thoroughly. And it would appear that what followed from that was a slight change in approach to the terminology used and the suggestion of warnings being applicable and perhaps a slightly less rigid approach. The Fair Work Agency is in the bill. The intention is it does bring together all of those different enforcement bodies, and there's provision about transferring staff into the particular agency. It's said not only that the intention is enforcement, but notably the press release, and perhaps speaking to some of the concerns that have been raised from business, is that this will also support employers looking for guidance on how to comply with the law. But it is still what is termed Labour's market enforcement strategy. And the powers to this agency will include the power to enter premises to obtain documents, to require documents to be produced, to interrogate what's on computers. The warning, it would appear to me, in the bill has become a labour market undertaking that can be sought from an employer. And so rather than seeking to bring direct enforcement, you can seek, or the agency will be able to seek a promise from the employer to improve their practices effectively. and so that would be an undertaking to comply with a particular market requirement. The next step after that appears to be envisaged in the bill is what's termed a labour market enforcement order, which is something that would be brought through the magistrates' courts or in Scotland through the sheriff court. And that looks very like an injunction to you or I. There is provision for criminal liability if such an order is breached, a fine, or if convicted on indictment, up to 2 years imprisonment. And so it is an agency that is intended to have real teeth. The agency is also intended to have a whistleblowing role, and it's said that it's to be a listening post. And so if someone goes to their employer and doesn't get anywhere, the intention is that they will be able to go, as well as to other bodies, to this agency. And it is bringing together minimum wage and statutory sick pay enforcement, the labour exploitation and modern slavery, and what at least is said to be something which didn't have enforcement provisions before, the right to holiday pay, is something that is intended to sit within the Fair Work Agency. This again is something where it's been expressly made clear it is not intended that this agency will be in operation before autumn of 2026. Moving on to pay, the government has already taken steps to remove what was seen as discrimination in adult pay because of the fact that there was a bracket from the age of 18 to 20, termed the national minimum wage, and thereafter the national living wage from 21 and over. So the age band of 18 plus is to go. The Low Pay Commission is dealing with now, for 18 and above, the cost of living and expected inflation. So the living wage will be the norm for those aged 18 and above. And the other important change through the bill is statutory sick pay is to be a day one right, and the lower limit of £123 a week is removed. The way that that's going to be removed is through consultation about what percentage reduction to the normal SSP should be for those who don't earn more than the lower limit. So whilst the lower limit will go, it won't mean that the person who doesn't get to the lower limit gets the full amount of statutory sick pay. They'll get a percentage of it. Again, subject to consultation. Family-friendly practices. We all know that the right to flexible working was actually brought in as a day one right on the 6th of April of this year. And so Labour had indicated that what had been brought in wasn't considered to be enough. What more could be done to bring that right more to the forefront? You'll all be aware, and I'd set out in the handout, of the specific statutory reasons for which a request for flexible working can be turned down: the burden of additional costs, inability to reorganise work and the like. What the bill does is reiterate that it must be considered from day one. All of the reasons remain the same, but the reliance on the reason must be reasonable. And so it introduces, if you like, a burden on the employer to show that their explanation, their reason for that request being turned down must be a reasonable one. You would hope that all the employers that we advise now would only rely on one of those reasons reasonably in any event. But it does introduce that additional element. The approach to flexible working, it said, is to be developed through consultation with business, trade unions and third sector bodies, and so it may be that some further guidance in due course is provided. In relation to pregnancy, there is protection from dismissal where pregnant, on maternity leave, and as things stand, the period after returning is not in the bill, but the press releases talk about a period of 6 months of return to work. So it seems likely that by the time that the bill passes through Parliament and becomes an act, the protection for those who have been on maternity leave will extend to 6 months after their return to work. For paternity leave, that's a day one right now instead of 26 weeks once the bill comes in. For unpaid parental leave, a day one right instead of 1 year. The way that bereavement leave is dealt with is previously there was a right to parental bereavement leave. And so the way that the bill deals with it is by deleting the term parental. And it suggests that bereavement leave should apply to any employee who, and the terminology is, satisfies conditions specified in the regulations as to the relationship with a person who has died. So as things stand, the extent of the proximity of the relationship that's needed to benefit from the potential bereavement leave right is unclear, and there will be consultation on how wide that term should be cast, how wide that definition should be. Within the various releases that came with the bill, has also been a commitment to consider, through consultation, how the parental leave system may support working parents better, and the obvious way that that may in due course be determined the obvious way that it may be found that parents can be helped better is by making that paid leave. And there is a commitment specifically to consult on paid carers leave. And so the type of payments like SSP payments may in due course be payments which are widened to cover things like parental leave, to cover carers leave. Within the press, as recently as the back end of August, there was reference to the idea of the introduction of a 4-day working week, or a move towards a 4-day working week. The Daily Telegraph reporting that various employers' organisations were petrified about that idea. The question I pose to you is whether the bill sticks with what we have, or whether there's any mention of a 4-day working week in it. The answer is that the 4-day working week does not appear on the face of the bill at all, and it appears to be something that, whilst it was mentioned, it's certainly on the back burner for now. The right to disconnect is a high-profile topic for Labour and has been for some considerable time. It was first raised in a Green Paper back in 2021. In the manifesto, it talked about the way in which the right to disconnect may be implemented. The suggestion that a model like that adopted in Belgium or Ireland, where they have adopted a code of practice about the right to disconnect, might be brought in. The intention of the right to disconnect is, however flexible your work is, there should be times when you can go home and disconnect, relax. So the answer is there's no mention of the right to disconnect in the bill itself, but it is included in the next steps document that was published at the same time as the bill. It's intended that there'll be further consultation on it. It's specifically stated that the intention is that this will be introduced, and the likelihood is that it will be introduced through a code of practice in the same, highly likely to follow closely in the footsteps of the position in Ireland. Fire and rehire obviously was a very high-profile area. Position already is that in July of this year, a code of practice on dismissal and re-engagement came in, but it's a code of practice that has its roots in the previous government, notwithstanding it was after the time that Labour came into government. Breaching that code as things stand could lead to an increase in an award of up to 25%, and the code provides for consultation and the like prior to any attempt to change terms and conditions. There is in the bill an intention to bring substantively an end to the practice of fire and rehire. It's not an absolute change, though. the way that it works is the approach of fire and rehire is supposed to be ended with the only exception being where there are serious financial problems and it's reasonable to do so in the face of those problems. And so on the face of it, firing and rehiring is a serious problem for employers unless that's happening where it's needed really for the viability of the business. The way that that's dealt with is sections 104A to G currently provide for situations where employees are treated to be automatically unfairly dismissed. And the bill provides for the introduction of a new section at the end of that list, where if the reason for dismissal is the variation of a contract of employment, and so where the employee is unfairly dismissed because the employer sought to vary the employee's contract of employment and the employee did not agree, or the employer sought to employ another person or re-engage the employee under a varied contract of employment but carrying out substantially the same activities, that dismissal will be automatically unfair unless the exception applies. The exception is effectively serious financial problems, and in all the circumstances, the employer could not reasonably have avoided the need to make the variation. The full wording of the financial problems provision as it stands in the bill is the reason for the variation was to eliminate, prevent, or significantly reduce, or significantly mitigate the effect of any financial difficulties which at the time of the dismissal were affecting, or were likely in the immediate future to affect, the employer's ability to carry on the business as a going concern, or otherwise to carry on the activities constituting the business. Pretty wordy, but really, I would suggest what it gets to is it needs to be a position where the business looks like it could go out of business, it could be the end, unless these changes are made. And if the reason is shown, there are still additional Section 98 factors to take into consideration, our basic fairness of dismissal. They will include the need to show consultation, the need to include discussion with the trade union where recognised, and whether anything was offered in return for the variation. In relation to trade union changes, there are substantial changes. First one, and perhaps most importantly, when an employee has a right to a statement of employment particulars, there will also need to be a statement that that employee has a right to join a trade union. That's to be in there from the start. Trade unions are to have a right of access to meet, represent, recruit, or organise workers, and to facilitate collective bargaining. Not a right of access to organise industrial action, but a right of access to ensure that trade unions have an opportunity to come in and speak to employees. The way that will work is there'll be a request for access, the employer must consider it and respond within a reasonable time, the employer can disagree, and the Central Arbitration Committee will determine disputes and enforce a right of access. The Section 168 right of trade union officials to have time off to carry out trade union activities is proposed to receive an addition of a right to accommodation and other facilities in the workplace in order to carry out the duties. There's strengthening of protection against blacklisting of trade union members. In relation to balloting, there is a removal of the requirement for 50% of those entitled to vote in an industrial action ballot needing to vote, and a replacement in the bill of the requirement for a simple majority of those who do vote. In relation to picketing, there's a removal of Section 220A of TULCA. Now, that's the section introduced which required the identification of a picket supervisor, the provision of an approval letter to demonstrate that the picketing was approved by the trade union, and the notification of the police about the picket, widely said to have been something introduced just to make it more difficult to picket. That will go, assuming that the bill comes into force. There's an addition of a detriment claim where an employee is subjected to detriment for either taking part in industrial action or to try and prevent or deter them from doing so. The recognition test for a trade union bargaining unit is to be, well, as things stand, it's 10% need to be workers who are members of the trade union when applying for recognition. The 10% will become instead the words the required percentage test, and then through statutory instrument, the Secretary of State will be able to change that 10% down to a number between 2% and 10%, as yet not identified. Fairly high profile, the Strikes Minimum Service Levels Act 2023 is to be repealed, and so all of the provisions in relation to minimum levels of service when strikes are taking place for health services, fire and rescue services, education, transport, decommissioning of nuclear installations and border security are to be removed. And unlike much of the bill, where there's a later date for implementation, the provision that's the repeal of that particular act is to come into force when the bill comes into force itself. Many of the other trade union amendments are to come into force 2 months after the bill, and the rest is to be when regulations say it should come in. In relation to collective redundancy, it's intended that the one establishment requirement, you may remember the Woolworths cases where, because it was deemed that each shop was a separate establishment, collective consultation was not said to have been a requirement. One establishment is simply to be deleted. And so where 20 employees or more are intended to be dismissed, collective consultation will be a requirement. Briefly, on equal pay, for larger employers who have 250 or more employees, action plans will be needed to both address gender equality, and so the obvious area there is pay gaps, but also, importantly, to support employees through the menopause. And so wherever you have a large employer, they will need to have action plans not only to look at gender pay inequality, but also to look at ways in which they can support employees who are dealing with the menopause. The intention is that those action plans will not be required to be published any more than every 12 months, but again, regulations to make that clearer. There has been a substantial amount of press around the idea that action plans on both ethnicity and disability pay gaps and plans to deal with pay gaps would be required. That's not in there, but the clear intention is that something like that will be included in the Equality, Race and Disability Bill. That may also include equal pay rights that are no longer based on gender, but may be based on ethnicity and disability. It's said that there definitely will be in the Equality Bill in due course an equal pay right preventing employers from outsourcing services to avoid equal pay claims. And many of you may be aware of the trend to outsource predominantly female areas of work, such as cleaning contracts, out of large employers. A number of local authorities have done that. It looks like the government will legislate in due course to try and ensure that you can apply a single source right the way across the main employment body and the outsourced work. And finally, to deal with pay in certain sectors, the bill provides for the establishment of an adult social care negotiating body, which is specifically to deal with pay for social care workers for adult social care. The bill also reintroduces the school support staff negotiating body, and on sexual harassment, taking reasonable steps will have the word all inserted in front of it, the clear intention to be make that more onerous. That can't be from the 26th of October because the bill won't be in force at that time, but work on the basis that that may be coming. It provides for regulations specifying what those reasonable steps might be. One would think that those regulations are highly likely to follow what the Equalities and Human Rights Commission has indicated. And there's also the intention to introduce a provision where employers must prevent harassment by third parties. And so where an employer has a third-party organisation come into the workplace, they are expected to avoid any harassment. And so if a third party harasses an employee in the course of their employment, and the employer failed to take all reasonable steps to prevent that third party from doing so, they may be found to be liable. Now, whether the all reasonable steps would include wanting to see the risk assessment that's taken place, the training that's taken place before someone comes into the workplace is yet to be identified. And finally, whistleblowing provisions are to be increased to specifically include sexual harassment. And so where at the moment one of the terms would be that a legal obligation has been or may be breached, there will also be that sexual harassment has occurred, is occurring, or is likely to occur. I think it's difficult to see how that would not be a breach of a legal obligation. Thank you very much all for listening. I hope that was a useful whistle-stop tour through the bill.